workers has been laid off in 2022 more than any time in recent history. As a matter of fact, 150,000 jobs in the tech industry has been lost in 2022. There's another report that says a lot of tech workers are finding jobs somewhere else quick, but not all of them. And therefore, we want to talk about termination or change of employment during your green card process. I'm Sam Shihab.
I'm Brian Burke.
And we're from the law firm of Sam Shihab and Associates. Stick with us, and we'll be back in a minute to break down the topic and answer your questions.
I missed it again, Sam.
All right. Just to repeat, we're from the law firm of Sam Shihab and Associates. We practice immigration law in the U.S. throughout the world. We focus on employment immigration law, and this is an employment immigration session that we do every Monday at 6 o'clock. Let's start with the visa bulletin update.
Yeah, well, breaking news, the February visa bulletin is out. Check it after this, but maybe you don't bother because essentially there is no change for the people who it sort of matters for most. India and China, the most backlogged region. I think I saw a little bit of movement on the other workers category for the rest of the world, but it's not really a popular immigration category. Well, actually that it's backlogged would indicate that it is, but bottom line is there's no great change in the visa bulletin that should, change anybody's life at the moment. In fact, no movement means no new green cards getting issued. Kind of a bummer. That's kind of it. When do we expect to see a more interesting visa bulletin, Sam?
April. I hope April is the second quarter. It looks like the agency or the State Department is looking carefully at the visa bulletin on the quarterly looks.
Yeah.
There doesn't look like they're really putting a lot of effort between the quarters, like in the 2 months between quarters, and we didn't see much movement before January. Then until January, they took them a long time to figure things out. The release was late.
Yeah, that's a sort of a flag for me when they start taking their sweet time putting those visa bulletins out the door. That's when you know it might be an interesting one. But we got one, timely. This month, timely.
Meaning that not much thought went into it, or they've decided to punt until April. So no news on the visa bulletin. Obviously, 2023. Those that joined us for the first time in 2023, Happy New Year. And those that joined us last week, Happy New Year as well. 2023 is a year in which there's a lot of debate on what is the economy is going to do for us. Another survey that came out this week, most analysts give a 61% chance of a hard landing coming out of the inflation into a potential small recession, and the rest think that we're going to have a soft landing, which I'm hoping that we do. Regardless, the tech industry has shedded a lot of workers, 150,000 in 2022. Amazon just laid off 18,000 workers.
Yeah, I saw a headline from today. It was, in May of 2022, Amazon had 32,000 and some change software developer openings, and as of today, they have 299. So
huge. Yeah,
I mean, they laid off a bunch of people, and they're not really adding much more back.
Yeah. So the leaders, the entrepreneurs in the U.S. all are saying it's going to be a slow year, it's going to be a tough year. So for us, who are going through the green card process, what do we expect in a slowdown year? We expect typically higher government scrutiny, although it may not happen this year. But generally speaking, looking back in the last 2 decades, whenever we have a slowdown or slowing down in the economy, we always see an uptick in scrutiny by the U.S. Department of Labor on labor certifications, or slowing down in approvals and tougher approvals at the USCIS level. However, with this administration, we haven't seen that, which is good news.
This is where I touch wood for some luck. It's a great H-1B climate still, but I mean, I can't help but agree with you on the Department of Labor. If the whole purpose of labor certification is to show that there's no U.S. workers ready, willing, qualified, and able to take a job that somebody's trying to offer a foreign worker, you can't help but think that they're going to look at the economy and say, if unemployment's going up, if there's not much demand, if there's people looking for jobs, how the heck do you make it through this process and not find a qualified U.S. worker? So yeah, you're looking at potentially longer processing times for green card cases influenced by audits, really. Yeah.
Yes. So diving into the various stages of the green card, we have a blog on our website that we're going to share with you on the screen. It's one that's been visited by a lot of people because we get a lot of emails on it. People say this was one of the most comprehensive analysis of different stages of the green card. If we can throw that on the screen, Brian?
Oh yeah, I'll throw it on the screen. And I also will note that it is, if you look in the description of our YouTube live stream, you'll find a link to that blog so you guys can peruse it at your leisure after this presentation. But let me put it up here. I realize I got to go to this screen over here to do it.
And it does break down the various stages of the green card process and if there's a termination during that stage. So you can reference this document. And I think it has a PDF printable version. Which you can just print it out, and there's about at least 10 to 15 stages in which different analysis.
Yeah.
So we very quickly, because this blog is going to take a lot more than half an hour to go through it, so we're going to just touch the highlights and then answer questions. Basically, just in simple term, and you guys are experts. If you're here on this video, on this YouTube listening to us, you're probably are in the employment green card process and you understand the process reasonably well. But there's three stages really. There's a PERM labor certification, there's filing, there's recruitment, then filing, then approval or certification. Then there's I-140, and then there is processing time, and there's approval, and then 180 days pass, and there are certain things happen. And then you wait until the visa bulletin calls your name, and then you file your adjustment status, and then you have to continue working until the green card is issued, or there could be retrogression, and you're stuck in the green card process. And at various stages, there is a different law that applies to what rights you have and you don't have. So let's jump right into it and go through it.
There it is right there. So we're talking about the first step of the green card process. It's PERM labor certification. That's when your employer does that test of the U.S. job market to see, hey, is there need for this person in the U.S. job market? They're looking for U.S. workers, see if there's anybody ready, willing, qualified. And the first stop we have on our list here is if you're terminated while PERM labor certification is pending. Now, I would clarify that you can leave a job while you don't have to be with your employer for them to pursue a PERM process. So it's always possible for you to leave a company and say, hey, can you guys keep that PERM going for me? They can be willing to do that. But if your employer puts a stop on your PERM process because you leave the company, let's talk about what happens. So
that's the simplest one and the saddest one, because really there's nothing, you lose all rights. There's no priority date issued, and the priority date is a coveted date because it stands you on the line towards the green card process. And if the labor certification is terminated during the recruitment process prior to filing or during the filing of it while it's pending,
that's it.
Then there's nothing, you start from scratch if you go to a new employer.
Yeah, I mean, I'm going to go even further to the next item on the list here. Is if you're terminated after PERM is approved, but before your I-140 is filed. So basically, great, your PERM was certified. If you leave the company says, we're done with you, and they don't want to pursue that any further, you still don't get a benefit. Even though, the priority date is the date you file your PERM case, that priority date is not locked in until you hit a couple steps down the process.
So no priority date, no ability to move any of the process somewhere else.
Nope.
No ability to extend your H-1B beyond its normal 6 years. No work authorization that can be issued to a spouse. Etc. All these rights are not yet at this stage of the green card. So if there's a termination of employment and termination of the process after the PERM is approved, but before the I-140 is filed, then there's no rights created.
Yeah.
All right, jump to the next one here.
Yes, so again, we go a little bit deeper. Now we're talking about, hey, we got to the point where we filed that I-140. So this is if you are terminated after the PERM is approved and after the I-140 is filed, but before it is approved, the I-140 that is, and the employer withdraws the I-140 petition. Yeah. We are still at a stage where you get nothing. You lose all the benefits of the PERM process, all the prevailing wage, the recruitment, that priority date, and any time and effort spent on that I-140, it's done.
Back to square one.
Back to square one, yeah.
No benefits whatsoever.
Yeah.
Okay, so we jump into the next one, and if the change of employment or the termination occurred within 180 days of the I-140 approval, and the employer withdraws the I-140, what happens? So now you kick into
some good stuff at least.
Some protection or some locked-in rights, and that one is the priority date is locked for you, and you have a priority date even if the employer withdraws the I-140. And that's before the 180 days. At any time, if he withdraws that,
approved for 1 day.
Exactly, 5 minutes later.
Yeah.
And they withdraw, you have a priority date.
Yeah. You get that priority date, and you can use that for your next PERM/I-140 process, green card process through your next employer. Awesome.
If you leave the country and go somewhere else for 8 years, 10 years, and you come back to the U.S., you can start the green card with a new employer and pick up that priority date and move forward as if you were in the process this entire period.
Ask us how we know that, because we've done it a lot of times before. It is kind of common, and people, we were just talking about this before we went live here. People go to Canada, and then when that I-140 date comes up, it's, maybe I'll come to the United States now, come here, file the green card.
100%.
Yeah.
So that is probably the most significant approval of this entire process, because truthfully, you stand in the line on that approval date, and
priority date, rather, yeah.
On the approval date,
that's when you actually formally get into line. Yeah, yes. I get what you're saying. Yeah.
But you get that date, obviously.
You have an ethereal force keeping your place in line, but that place in line is not yours until that I-140 has been approved. Yeah.
And then you get in that line, and whatever happens, and I'm sure a lot going to happen for you professionally and personally between that first I-140 approval, if let's say you're born in China or India and in your backlog country, and the actual green card approval, which is many years into the future, but that I-140 approval is the single most significant event for you because it locks that priority date.
Yeah. Sam, I want to take a pause because I see it up here, because your I-140 employer, you got it approved for 1 day, they terminate, and then what do you do? We've got to talk a little bit about the H-1B stuff. So really, what we're talking about is the H-1B 60-day grace period. H-1B 60-day grace period. If you are terminated by an employer while you're in valid H-1B status, you get a grace period. That grace period lasts 60 days. Or until the end of your current H-1B approval, whatever is
I-94 date.
Yeah. Your I-94 date is correct. Yeah, whichever is earlier. So if you have an I-94 that's valid, 2.5 years left on it, and then you get terminated, you get a 60-day grace period. But if you get terminated when you only have 30 days left on your H-1B I-94, you have a 30-day grace period. Is the bottom line. So you don't really get anything extra from the H-1B grace period in terms of ability to stay in the United States, but you get some flexibility the rules are they won't consider you to have violated your H-1B status for lack of gainful employment for up to 60 days during the validity period. And Sam, it's crazy. This is something, I've heard about on the radio lately. My mother sent me a text message. She said, Brian, have you ever heard of this thing, where foreign workers, she said, have 90 days to find a new job? And I called her up. I said, no, it's 60 days. It's called the H-1B 60-day grace period. So interesting times. It's kind of a popular topic in the news, something I've read a lot of news stories about lately, which is kind of bizarre as an immigration attorney who doesn't hear about this.
And these are different spheres. So the green card priority date has nothing to do with the H-1B, but I think talking about the H-1B now is important because I don't want people to confuse it with the priority date. These are completely, at least right now, they run in different spheres. Yeah. They crisscross down the road, but right now they're completely independent.
Yeah, so I'll carry this out further. You can leave sorry, we got to terminate you. Your I-140 is approved for 1 day. Congratulations. We're terminating your H-1B as well. You can use that grace period, or like you suggested, Sam, you could just leave the United States, keep an eye on that priority date and come back, 8 years later, and you're going to still have the benefit of that priority date. It's an entirely different thing. You've lost your H-1B, you've lost your job there, but you're still keeping that priority date. So
yeah. And there is no laws that changes that right now. The only way that priority date is lost is fraud, misrepresentation.
Yeah.
That if it was revoked approved by an error.
Yeah.
If USCIS approved this by error, they say, this I-140 should not have been approved. We made a mistake. Or if there was a fraud and misrepresentation, then
Yeah, and you mentioned, there's there's no changes on that on the horizon or anything like that. And in my experience, the laws on this have only gotten clearer and better in the time I've been practicing as an immigration lawyer. They've been nicer to people, making it very clear when the benefits kick in and when you lock your priority date, things like that. So it's good times.
Let's look at the next scenario.
Yes, sir.
So with the next scenario, Brian, take that one for us.
Yeah. So if you are terminated within 180 days of I-140 approval, and the employer does not withdraw your I-140 within 180 days of approval or withdraws at any time after. So
in other words, the I-140 is valid for at least 180 days.
Yeah, left approved for 180 days or more. So
there's additional rights you get here.
Yeah. So essentially, the employer, after 180 days, they can send a withdrawal letter to USCIS and say, we withdraw this I-140. And USCIS's response is, okay, well, we understand that you no longer support this job, but that I-140 is not withdrawn. It is basically the beneficiary of that I-140 could use that I-140 to extend their H-1B status to beyond 6 years, and that's really great. It can still also be used for the spouse to get, like it says up there, to get the H-4 and H-4 EAD. So
all what you need is an I-140 approved for 180 days, and after that, if it's withdrawn and you move to a different employer, and this new employer will have to start the green card process potentially fresh from the beginning.
Yeah, new prevailing wage, new recruitment, new entire labor certification process, new I-140. Yeah.
But the foreign national is allowed to continue H-1B beyond 6 years if they're running out of H-1B time, and their spouse, whether or not they're running out of H-1B, the spouse gets an employment authorization document to be able to work at that time.
The only thing that gets a little bit complicated is that, if your priority date becomes current and you don't have an employer willing to file your adjustment of status, it could be difficult to extend your H-1B status. But that is what it is. One thing we haven't mentioned, though, Sam, was we're talking about these I-140 withdrawal scenarios. What we haven't brought up is it's always possible to go back to any employer that has filed your I-140. So, let's go to the kind of weakest I-140 based scenario. Somebody, you got the approved labor certification. Yes. They filed your I-140. Awesome, you're excited. And then, a week later they say, oh, we got to withdraw this I-140. Our company, we just can't justify our position anymore. Well, that's really bad right then, but doesn't necessarily mean it's the death of your labor certification. If at any point in the future the company is willing to support that labor certification, refile that I-140, they can do so. Ask us how we know. We've done it a lot, and that's it. As long as the rules of the labor certification, as long as the labor certification was submitted to USCIS in a properly filed I-140 petition, timely, it's possible to come back later and get it later and revive a withdrawn or even denied I-140 petition by refiling it later and getting the case approved, of course.
So we clarify. So there is a critical additional rights you receive if the I-140 was withdrawn after 180 days.
Yeah.
Or if the employment is terminated and the I-140 is withdrawn after 180 days. Now, you could be terminated, or the employee could be terminated, but the I-140 could continue.
Yeah.
The employer could have, I don't have a job for you right now, but I have a job for you when the green card is available 4 years from now. I will give you a job, so they can continue that I-140 if there's a good faith job available and a good faith offer available for the foreign national. then you could move somewhere else and that I-140 continued. But if they don't have a job, and if they withdraw the I-140 180 days after, there are additional rights you receive, which is the H-1B beyond 6 years for the H-1B beneficiary, and the EAD for the spouse of the beneficiary.
Now, something I just got to bring up is that 180-day mark can become a point of negotiation. You know, if you guys are educated and you know where the important day is, you know, and you know your employer is, you know, announcing layoffs, it's, you know, find a way to stay with the company long enough such that, you know, you cross that 180-day mark. And I know for a fact that a lot of employer HRs aren't really thinking about that very much. And if you're thinking about it, you can kind of derive the benefit if you can basically extend your employment long enough such that, you know.
And if they can't, just tell them, just don't withdraw the I-140 until 100 days. So, and a lot of companies don't even think about I-140 withdrawal.
Yeah. A lot of companies just don't withdraw. A lot of employees like to keep the door open. Yeah.
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 So it all depends, and you have to strategize based on your case and your circumstances. But these are opportunities for you if you're in a situation where the employer is potentially is terminating, or you're moving on and you haven't crossed the 180 days. You can try to leave the I-140 life for a few more months or a few more weeks to cross the 180-day magic mark. All right, Brian, so let's go to the next scenario here.
We are moving into adjustment of status-based scenario. So you've gotten your I-140 approved with somebody, and you've made it so far that you have your I-45 filed. And let's check the, well, we're kind of regress on some of these issues, but it's an interesting one. So
yeah, so these are kind of a specialized scenarios, but it happens. So if you are terminated while both the I-140 and the 45 are pending with USCIS, and the employer withdraws the I-140 petition. So in that scenario, did the employer withdraw it before 180 days, Brian? I think this one is before.
Yeah.
Because I think that it should be clarified, right?
Yeah, I would agree with you on that.
So the next one, it says, I think after 140 days, right?
Yeah.
So this one here, the one above it, and we'll probably make a note to clarify, if you're terminated while both the I-140 and 45 are pending with USCIS, an employer withdraws the I-140 petition. So let's say the visa bulletin was current, the I-140 is approved, you file the I-140, you probably filed concurrently with the I-45.
Yeah, I think that's what this scenario is describing.
And then the employer withdraw the I-140 before they cross the 180 days.
Yeah, 180 days of filing.
And that's critical here for that scenario.
Yeah. Well, that's it. You know, you don't secure the priority date because your I-140 never gets approved.
Yes.
Your I-45 application will be denied because it's within 180 days.
Yes.
And basically, you're kind of back to the drawing board. You lose a whole lot there.
Yes.
Yeah.
So that one is really no different than the I-140 is not filed, or the I-140 is filed but not approved and withdrawn. Yeah. If you add an I-45 that's current, because the visa bulletin is concurrent with the I-140 because the visa bulletin was available, it doesn't change that the I-140 wasn't approved, and the withdrawal of the I-140 causes the loss of that priority date, because, as we said, the I-140 must be approved for that priority date to be current, to be locked in for you. Now, next scenario.
Yes, so this is where you're terminated within 180 days of I-140 approval, and within 180 days of filing I-45, and the employer withdraws the I-140 petition. So terminate within 180 days of I-140 approval.
So so we're clear, so people are not confused. I-140 has been approved.
Yes.
Okay, but 180 days have not passed yet, and then you file an adjustment at the same time.
Since the adjustment of status filing. Yeah.
Okay, so that one is very similar to the I-140 approved and withdrawn within 180 days.
Yeah. Yeah. So essentially, your I-140 is approved. Great, you get the benefit of the priority date. But without, if your I-45 hasn't been pending for more than 180 days, you don't get the benefit of the portability rules, which we'll be getting into soon. Meaning your I-45 is going to be denied. And
if they're considering if they're considering your case now. So, a lot of time USCIS takes them 1 year to even look at an adjustment of status.
Yeah.
So if there is a withdrawal, what happens if the USCIS does not act on it until after 100 days? The fact that the I-140 withdrawal was sent before the 180 days, I think
that would be enough for them to eliminate the
both of them.
For those who don't know, I mean, occasionally we are asked to withdraw H-1Bs and I-140s, right? And it can take USCIS literally years to process those requests. But that won't stop them from, denying somebody's case when they eventually figure it out, years down the road. Oh, I'm sorry, we're going to have to withdraw this adjustment, deny this adjustment of status because the employer, even though it's been pending for 3 years, because the employer withdrew the I-140, during that time frame.
Yes, and therefore, if they withdraw the I-140 and they did not give you a chance to cross the 180 days, and this is where you negotiate hard with your employer, trying to keep them without withdrawing the I-140, and have them cross the 180-day mark after the approval of the I-140, because it creates all these wonderful opportunities for you.
Yes.
And negotiation is very important at that point.
Yes. Now, my recollection of the blog here is that's why this section is green, because this is when all the good benefits start to attach here. So here's the scenario. If you are terminated after 180 days of I-140 approval and within 180 days of filing I-45, and the employer withdraws the I-140 and the priority date has become current, well, I-140 approval, this blog is so complicated, Sam.
Yes.
Well, the I-140 approval means your priority date is locked, but in your priority date is current, USCIS can start, USCIS, they're going to say, hey, we're processing your case, and you might get a very interesting request for evidence. If they, that's when you're going to start seeing these Supplement J RFEs, right?
So first of all, let's set this stage up here for people to understand it. So because the withdrawal is after the 180 days of the I-140 approval, the I-140 technically is considered alive for certain purposes, not for the purpose of this job, but for the purpose of perhaps a new employer. But obviously, number one, your priority date is locked. Let's make it simple. You can extend beyond 6 years your H-1B because the I-140 is withdrawn after 180 days. So you got the ability to extend your H-1B with a new employer beyond 6 years. Your spouse gets to do the EAD, and that's good. Now, the question is, can you port, because the adjustment of status has not been
processing for 180 days.
Processing for 100 days. Now you get an RFE.
Yeah.
Why 180 days on the adjustment status is critical? Because after 180 days, and we're going to jump ahead of ourselves a little bit to explain this, after 180 days of adjustment, you could
port.
Do AC-21 on the I-485. You can move your I-485 to a new employer. So why it's critical? Because if they have to make a decision before you cross the 180 days, that adjustment will be denied. Yeah. The good news is an RFE, a lot of time, will take 2 or 3 months.
Yeah, I mean, the classic, regulatory required amount of time on most RFEs is 87 days. Plus, right now in the COVID policy world, we have an additional 60 days on RFEs. So it might be possible to, wait out the 180 days and basically, make the portability argument thereafter. Now, in theory, it's always possible that USCIS can do a deep dive investigation on this, and this is always an interesting topic, but we've successfully navigated this scenario. It's not a scenario I would wish upon anybody because it's one that makes you sweat a little bit, but it's something where your adjustment of status might be able to survive that. You might be able to take advantage of portability.
So the time it takes for an RFE could be where it will save you. Obviously, with COVID and the time extension on the RFE, we've had opportunities.
Yeah, I mean, you get almost 180 days on an RFE as it is.
And that's all what you need. But RFEs could be as short as 30 days. And if the RFE is short as 30 days and that 30th day does not cross the I-485.
Your portability request.
So you may have to withdraw the I-485 and move your employment somewhere else and start all over again. Your priority date is locked. You can go beyond 6 years on the H-1B, and then you got to start all over again. You cannot move your adjustment in that scenario. All right, so I know that we're going to run out of time with this 6:31, and there's a lot more stuff to discuss.
Yeah, I know. I keep on thinking we're coming towards the end, but we have 1,001.
There's a
little
million scenarios here.
Yeah.
So I will do the next one, and then we'll stop.
Okay.
To take questions.
Okay.
And we're not going to spend too much time because a lot of people have questions.
Yeah.
So, and if we have time at the end, we'll go back to it. So let's move on to the next scenario.
So yeah, I'll go ahead and read it out. So if you are terminated prior to 180 days of your I-140 approval, so I-140 not approved 180 days, but after your 180 days of filing and I-45 employer, sorry.
Isn't this the same one? Did you
No, it's this is a little bit different. That's, you haven't made it to the 180 days of, I-140 approved, haven't made it to 180 days of I-140, but you have made it to 180 days of I-485.
So the I-45 is 180 days.
Yeah.
But the I-140 is not 180 days.
Yes, but because you made it to 180 days on your I-485, basically that controls at this point. You're able to port. They won't care that your I-140 wasn't approved 180 days, and that's why the explanation here is so short. Employer can change the same or similar job classification using Supplement J. USCIS will not deny a case and give the chance to file a Supplement J to basically use portability.
But what about the I-140? No, they give you a NOID, and if the I-140 is so the I-140 has been approved but hasn't not been 180 days.
Yeah, but because the adjustment of status has been pending for 180 days.
So this is a unique scenario.
Yeah.
In which
I'm thinking a long process. An I-1 simultaneous filing I-140, I-485. You file the I-140 without premium processing. You file the adjustment of status at the same time. So your I-140 just barely made it approved, but your adjustment has been pending as long as the I-140 was. That's a scenario I think of.
Another scenario is if you've done a transfer underlying basis to a new I-140.
Yeah.
So over that resets the clock. That's not the right scenario.
You're right. Yeah. So
that's not
oh my God,
everybody.
Sam! This chart's going to have transfer of underlying basis on it as well.
We haven't added that yet to it, but that's an interesting chart. So I think we can probably, if there's an interest, we'll probably carry that on until next session. If there's no interest, we'll move on to a different topic next week. But we wanted to kind of give you a flavor. Look at that blog. It has most scenarios. It's really probably, I've been told by people, it's one of the most comprehensive blog on this topic available out there. On our website, immigrationvisaattorney.com, and the link is on the bottom for you, and it's an interesting details to it. And when we return, we'll be answering your questions. All right, so this is when I have a moment to remind everybody that we try to answer questions based on general and limited information. So please do not rely on our answer and hire a competent attorney of your choice to assist you to make a decision on your case. And obviously there's no attorney-client relationship established in having that virtual exchange of ideas and thoughts on this YouTube channel. With that, let's jump in to the first one.
Well, at first it's a bit of housekeeping. How to ask a question? Well, I think Asghar there found the way to do it. Just put one in the comments there, and as long as we have the time, as long as it's appropriate, we'll do our best to answer it.
I think he's cute because he's asking you a question.
Yeah. Well, congratulations, success.
All right.
So let's see what Regini has for us. Oh, a great question. What was the actual reason for family-based numbers moving to employment-based from 2020 to 2022? COVID was there. Was it the president's order to stop consulates working abroad, which facilitated the movement? So, more of a, I would have to, go back and check the records as to why consulates get closed. But I mean, it was COVID.
Because everybody was sick.
Everybody was sick.
I mean, to conduct a interview for a family, an interview, you have to see people in person. And not only were the officers sick, and those who were not sick couldn't risk.
Yeah, I mean, no vaccines available. Peak spread masking policies weren't in place. It took them a long time to get all that stuff.
A complete and absolute breakdown at the consulate level worldwide, which shut down any ability to.
Yeah, I mean, I'll spout my favorite numbers. Usually in a given month, and we were looking at this, late last year. An average month is like somewhere between like 15 to 20,000 visas issued at all the consulates. These immigrant visas issued at all the consulates around the world in a given month. And in like March of 2020, when COVID just like really kind of hit it, I saw numbers as like a couple hundred, visas issued at the consulate. So yeah, they basically closed themselves down and that's it. And they just did not bring people in for interviews. Thereby, they did not issue family-based visas. And for those who don't know, family-based visas, family preference visas, when they don't get used, they roll over in the next fiscal year into the employment-based category, and that's how we had massive visa availability in terms of fiscal year 2021, 2022, and still an increased visa availability this year. We have an additional 50,000 visas available to us.
Isato is asking, can you travel on an H-1B stamp with only 2 months left on it? So we always tell you that you can travel outside the United States under any circumstances. Nobody stops you from leaving the country. Yeah. I think the question is, can you re-enter? And the only thing that you have to present is a valid passport and a valid H-1B stamp on the day of your entry. So if your stamp is valid for 1 day and today you present yourself to enter the U.S., you will be allowed to enter, provided that you have an employment here and you provide the necessary documents. Yeah. So leaving the United States is not a problem, and coming in is absolutely not a problem on 2 months left, or even on 1 day left, or 7 days left. Of course, I won't let things go.
Now, see, I'm going to imagine the extreme scenario, Sam, where somebody, comes in the United States with, a week left on their visa and a week left on their H-1B approval, meaning they're going to get a 1 week long I-94. I'd say you're putting yourself in a difficult situation. You need to actually, check your eye. So if you're traveling, here's a general advice. If traveling, check your I-94 to make sure that you extend your I-94 timely after you enter the United States.
But technically speaking, it's approved.
Oh yeah, for sure.
This is for you.
From Sarabi Verma, how does O1 visa apply for green card? Does the applicant still need to go through the employment-based categories such as EB-1A or the other means? Can you please explain the process, please?
Okay, that's a good question.
Yeah.
So, and there was another question that came, is how is O1 visa different from national interest waiver? People are confused about that. So maybe you can throw that in there in your answer.
So, O1 folks have multiple paths to a green card. I mean, they could really go down to the, O1. They can go down to EB2 or EB3, do a labor certification-based green card if they desired to. There's the, but fundamentally, there's higher level visa categories that might be appropriate for them. There's outstanding professors and researchers, and there's the it's the immigrants of extraordinary ability, I believe, is the EB1 category there. And essentially, most of those processes, the higher level ones, allow you to skip the labor certification process. It's essentially a very complex I-140 application where you basically lay out the requirements there. It's an entirely different process than a labor certification-based I-140, where you go through the Department of Labor and test the job market. It's basically establishing that you meet a criteria that is so high such that you get to skip all those processes. It's just essentially an entirely different grade of green card. You file it on I-140. You provide evidence to show that you meet the requirements, and that's that. It potentially can be a quick way to a green card, and obviously skipping the labor certification process. And for folks who are from backlog countries like India and China, being in the EB1 category is great.
What about the O1?
So what do you mean? What do you mean about the O1?
O1 is filed also through a labor certification potentially. So you can do a labor certification for O1.
Yeah. I think one of the things I said is you can do an EB2, EB3.
Yeah. So the treatment is the same. Yeah.
Yeah. Okay. And yeah, those folks have whatever categories of green card they qualify available to them.
Yes.
Yeah.
So from Bati Varun, is it a good time now for priority date January 2014 to move into a green card EAD as the final action dates retrogressed and not sure when they would move forward again? Well,
I think there's a follow-up here from the same individual, so let's may as well
let's
check
do
it
that.
out.
Sure.
Can I work 2 full times in the green card EAD? Example, with one petitioning employer, employer A, and other with new employer, employer B. How do you justify that in case of an I-45 interview? A great series of questions.
So there's a lot of parts to this. So is this a good time to get out of my H-1B and work for EAD? I have opportunities to work a lot of jobs, double jobs, make more money.
It sounds like, what's probably in Bati's head is that this,
Yeah.
I can if I did more than what I was allowed to on H-1B.
Yeah, not only that, I mean, he may be feeling that his employer job opportunity is weakening.
Yeah.
Economy is soft now on tech, which is the first time in a long time.
Yeah.
And he wants to be flexible. It's not a bad time. The key for you is to, number one, have an opportunity for employment, because you really have to have a job offer.
Yeah.
A permanent job offer, or somebody willing to do a supplement J for you, and continue the green card process, right? That's the most important thing, in my opinion.
Yeah.
The second thing is, can you work on 2 jobs on green card EAD? Absolutely.
Sure.
And let's say you go to the interview, and the question becomes, who is going to be your green card employer? Is that the original adjustment status I-140 employer, or is that one of the new ones? It doesn't matter. As a matter of fact, it's the same thing. As long as you have one who is ready to give you a bona fide job offer, and you're willing to work for them. And why are you working for 2 jobs? Because I want to make more money. Yeah. There's nothing wrong with working with 2 jobs whatsoever. Even they could also be not related to the green card employer who told you that I will give you a job when the green card is approved. So I don't see a problem. So if you get to the point where you need an interview, to be interviewed, you really need to have counsel to help you either prior to or during the interview to show you how to deal with the intricacies of the interview. But I don't see red flags.
These are questions I hear a lot of. But my usual answer on these is, hey, calm down. You have, you're in high demand, and fundamentally, as long as you have somebody offering you permanent employment, you're good. Yeah. You have a broad breadth of choices at you. I would note that this scenario, working for multiple employers, doesn't require use of the green card EAD. If that other employer, that employer B, is willing to do a concurrent H-1B, I know a lot of companies aren't, but if that employer is willing to do a concurrent H-1B, you can have the best of both worlds. Keep your H-1B status, if you want.
Or he can take contract jobs.
Oh yeah, that's the benefit of the green card EAD for sure. There's a lot more flexibility there.
Yeah. So I'm hearing here, unable to hear you. This is the first one we heard, so I'm assuming.
Yeah, it might have been
on your end, not on our end, because we've had a bunch of people here watching us for quite some time.
And one thing I know about our audience is they will tell us immediately if our audio is not working properly, which is why the very first thing I do when we go live is turn on the chat to make sure that nobody's telling us there's problems here.
Yeah. So we're going to assume that if it was a problem, it's fixed itself.
And also, I know certain members of our staff will call the conference room right here and tell us if our audio is not.
This is 18 minutes into our presentation. He's saying unable to hear you.
Oh, dear. Well, let's keep on going here. So I've looked down to the end. I don't hear anybody saying that they can't hear us. Maybe we had a brief hiccup in the audio. Please let us know if you're having any sort of issue there.
Yeah. All right, sounds good. So let's go into the next one.
Yeah. So, interesting one. So on pending asylum with approved permanent I-140, can I do adjustment of status while staying in the USA? You handled one of these pretty recently, and I think the answer is the devil's in the details, right?
Generally, yes, if. So asylum is not a status. Asylum is not a status, and you must be in status to get the adjustment approved. However, for asylum, because of the lengthy adjudication, there is a regulations that allow for you to be excused if the asylum was filed when you were in status. And then you got out of status because of the lengthy asylum adjudication. It's taking decades to approve them. So the devil is in the details, as you said, right on. But absolutely is doable, and we've done it before.
Yeah. So, a question from Momo Lee. Greetings. I applied for I-485 in March 2022 and still have not received an EAD. I did an expedite request 4 months ago, which was denied. My H-1B is valid until 2024. What can I do? Will lawsuit work? A great question. March of 2020. That's a really long time. So, first of all, is that a long time? And Sam, I'm gonna do something crazy here. I'm gonna go to the USCIS website while we're talking here, and I'm gonna check the processing times, what USCIS says for an I-765, because I feel like it.
Why not?
Yeah, why not? So there it is. I'm looking it up. I-760. Here it is. I-765 application for employment authorization in the pending adjustment category. Now, there's a couple service centers that are processes. We don't know where yours is at, but 16 months, California National Benefits Center, 8.5 months, Nebraska Service Center, 14.5 months. So that sounds like a long time, Sam, but Texas Service Center, 14.5 months. Vermont Service Center, 11 months. It sounds like that is really kind of within the processing times. It has been in process for a little bit less than a year, and we're seeing processing times that are, frankly, more than a year.
That's ridiculous.
I would fully agree. And honestly, Sam, I do a lot of consultations with people saying, talking about the green card process, and I warn them, I say, there's these interim benefits where the government intends you to give you an EAD and advanced parole while your green card is pending. But then I say, realistically, it is more than possible that you will get that green card in your hand before they even consider looking at that EAD and advanced parole application. So, what can I do? Is fundamentally the question here from Momo Lee. How do you feel about a mandamus action?
You can file a mandamus action. I mean, there is going to be a pushback, and the argument that before the judge is within processing time. But I think processing time data, we all know it's garbage.
Yeah.
And it is not a reason for the incredibly excessive review process. Because if the judge has to rely on the government's processing time to excuse them from doing their job, then the slower they are, the more defensible they are, which doesn't make any sense. So I think this is an excessive time. I think, I would file a writ of mandamus 100%. 100% I'd file a writ of mandamus on this case.
Yeah, I would note, expedite request denied. USCIS, I find, is often reluctant to approve any sort of expedite request when you have unemployment authorization, when you have an underlying employment authorization. If you have a valid H-1B to 2024, that for them might be enough reason to say.
But he can say that my job is in jeopardy and I have opportunity somewhere else.
Yeah, so that is something, when people have been coming up against, I have no other employment authorization, that's something where, even though in their policy, on their expedite policy, it's just not having a job, not being able to work is not something that usually makes us expedite. I've seen that work before.
But I would do a writ of mandamus on it.
Yeah.
I mean, you may not win, but it's so frustrating. You got to start doing these things.
Yeah. Fundamentally, when the government starts getting really bad, that's when people start suing the government, and when people sue the government, that's when things get better. The big example from 2 years ago was the H-1B litigation, and now it's a really nice time to be filing H-1Bs.
Yeah. I mean, we get abused for 10 years.
Yeah.
10, 15 years. You get slapped around. By rules, they were just grabbing stuff from the air, absolutely not based on law.
And then they started just grinding them into us, and I mean, just the denial rate on H-1Bs went from a couple a year to as many you get in a year in a month, and then some.
And all this is based on fabricated law.
Well, yeah, it just change. Yeah, exactly. Yeah. So.
All right, so let's go in the next one here.
Yeah, a very much on-topic question, it appears. So from Suresh M. My company laid off 80% of IT employees and outsourced those positions. Many of these outsourced positions moved to offshore India. How will this affect U.S. economy and EB immigrants?
So that's an excellent question. And obviously, if there has been lawsuits because of these things happening. Well, one of them is the Disney lawsuit. It's very famous. Although these were U.S. workers that sued, and they lost, as a matter of fact, because they were doing everything correctly. It is not a good thing for companies to do that, but it's being done. Whether you are a foreign worker or a U.S. worker, when they lay off their employees and use outsource IT from outside the country, we got a problem, and you got a problem. Now,
I mean, I have a little bit of commentary for Suresh here. Suresh says his company, meaning suggesting he's still with it. So if he's an employment-based,
maybe he's laid off too.
Maybe so.
We don't know.
So I mean, I think of people going through the labor certification process. You know, if you have layoffs in the occupation, if the company has layoffs in the occupation in which they're seeking labor certification, if somebody is in the labor certification process of that company,
it's dead.
Yeah, odds are the labor certification process is dead. It stops people from immigrating to the United States. Now, if you have an approved labor certification, that does not invalidate it once because it's been approved. You have secured the priority date. But obviously, you know,
it's a tough situation. So, but the question: how will this affect the U.S. economy and employment-based immigration? Obviously, the U.S. I mean, I just started. If you were with us at the very beginning, there was a report that said 150,000 tech jobs lost in 2022, more ever than any time before in recent history. And you know, Amazon laid off 18,000 workers. Brian, you shared the numbers on
Amazon job openings went from 32,000 in May to 300 in as of recent.
Yeah. So that's huge, and other layoffs. Obviously, we all know about Twitter. We all know about other companies.
Yeah, and we are so basically, you know, people with at that company with employment-based green card processes in the IT department. Odds are those cases are dead. Those who are in the IT realm and, you know, make it to filing a green card, when economic bad times come, the Department of Labor is more likely to audit cases. And for employment-based, you know, H-1B, any other type of visa, USCIS is going to put more scrutiny on any type of visa.
But here's my take. Our economy things are funny. We were hiring like crazy. As a matter of fact, we're still hiring. They're saying that the job market in general was very tight. There was about 5 to 7% increase in salaries because employers were not finding workers. On the other hand, we're seeing layoff in the tech industry. And a year ago, you couldn't find people were hiring with vicious appetite. Things can flip around very quick. I bet you by the third quarter of 2023, we're going to go back to I can't find IT workers. So this is going to be short-lived in my projection. But normally, the government scrutiny goes up during these times. We haven't seen it yet, but normally that does happen. All right, so we got a few minutes left and then get a bunch of questions.
This is a favorite question of my kind from Prasad. What are the basic steps which we need to follow for employment-based green card interview? So let's do a plug for our YouTube channel, which we're actively on right now, Sam. We've done in the past some videos, speaking of ones where people call us about them, email us about them, ask us about them. Our employment-based, you know, green card interview videos.
I think we have a mock interview, right?
Yeah, go through. I think it's the minute-by-minute green card interview. People have said that's the best, you know, employment-based green card video out there on YouTube. It's just me.
For the interview.
Yeah, me and Sam talking about.
Brian was the immigrant, although he looks like he would be the lawyer, and I would look like I'm the immigrant.
I could be Canadian. I could be Western European.
I played the lawyer. And he played the employment-based immigrant, and we did a mock interview, which was fun to do.
Yeah, no, we should do another one of those because those videos are always fun to do. But my number one, I'm going to give very unusual for me one-word advice: preparation. And for me, that means review your green card case to see if there's anything that you missed the first time. You know, because fundamentally, when I think about employment-based green card interview, they don't interview everybody. So the question is, why are they interviewing me?
My one-word advice is similar to Brian, but mine would say, ask yourself, why am I nervous? There must be something in the history of your case that's bothering you. Bring it out. Bring it out to the lawyer. Let's dissect it, make sure that we got you protected. A lot of people may have a legal infraction. Other people may have a gap in status, and they're just covering it and hoping it'll never come up. Just bring it out. Let the lawyers help you deal with it and prepare you how to handle it.
I have gone to interviews with people, and I've talked with them for far too long about 1,001 different issues that may come up, and you go to the interview and nothing comes up. I'd rather be prepared for issues that don't come up rather than. I've also been seen people just get sideswiped by an issue that they didn't think USCIS could have known about, and I've
Yes.
I have a guy in mind. He still got his green card, but preparation is important for him.
Yes. All right. So
keep
moving
it
on
going
to
here.
let's go to the next one here. Can we travel on valid advance parole while the advance parole and EAD renewal is pending with USCIS? The answer is yes. Right now, with the current policy, as long as you're traveling on a valid advance parole. And just be prepared to come back within the validity period of that advanced parole. Don't count on USCIS approving the next one, and don't stay too long outside the country. That's my advice. What do you think?
No, I think that's 100% solid.
All right.
Now, next question here from Pradeep, who listened to something we said, and this is here's the question. Hi, Sam and Brian. Hello. Friend relocated to India in 2009 and has an approved I-140 with priority date in 2004. Is he eligible for cap-exempt H-1B? So I guess my question is he would have had to have made it to the U.S. before on H-1B status.
Assuming he did, obviously. Otherwise, he wouldn't have an I-140.
Yeah. So that 2004 priority date is a problem. Once your priority date has been current, once your priority date is current, they don't allow you to extend to file for H-1B.
So the limitation on that beyond 6 years is when your H-1B is current. If the H-1B is current, then you have to act on that green card within 1 year.
Yeah. However,
I would do consular processing for a green card if he can find the old employer who's willing to hire him.
Find any employers. He still has his priority date. Find any employers willing to hire him, and
You file an I-140, but you need an I-140 approved.
Yeah, you need a permanent I-140. But if Pradeep's been in the industries, I'm going to presume he's been in IT. It's common for H-1B folks. He's been out there since 2009. He's got probably 15 years of experience at least under his belt. I'm sorry, since 2004, he's got a lot of experience under his belt. You find somebody to sponsor you. It's
I-140 premium processing. Well, you need labor certification.
Labor certification. Somebody who does a lot of them might have a prevailing wage you can reuse.
Or find the old employer.
Find the old employer. Yeah.
So if the priority date, God forbid, retrogresses to prior to 2004, then the answer would be yes for him.
Yeah.
But that's a good question. That's an excellent question.
Yeah.
All right. We got time for one. Maybe if we're quick, two more.
Yeah. So from Naresh Kumar, during green card interview, the employer asked about my wife about past work experience and said might need some documents. And a little bit of follow-up here. She took a break from IBM India when she was in the USA from 2019 to 2021 and went to India till 2022 and worked for IBM India again for 6 months. Is this an issue? So I don't really see anything there. Usually when I think about employment-based green card interviews, and I'm presuming this is Naresh Kumar's dependent spouse, right? My opinion and estimation of USCIS is they're not usually very interested in the work history of a spouse, so long as that spouse has maintained their status in the United States.
The only question is whether or not she's maintained her status. Otherwise, zero issues, in my opinion.
Yeah.
All right, taking the last one here. Can we travel on valid advance parole and return while EAD advance parole renewal is in process with USCIS? I think we answered that one. So we'll take joint late. What's your green card prediction for India EB2 and EB3 considering layoffs happening which may result in less filing due to 6 months green card sponsorship freeze after mass layoff? Well, we did not do a prediction, Shashi, and I am going to sleep on today with that prediction because it's hard to predict anything right now.
Well, we had a prediction. It was look to the April visa bulletin. That's when you're likely to see
any
some
changes.
movement. Yeah.
But obviously slowing down in the economy clearly is positive for those who have a visa bulletin date that's soon because there could be people dropping out in the pipeline. and that could create
Yeah,
opportunities.
if they don't get cases that match their expectations, they adjust the visa bulletin accordingly. They should.
Yeah.
Yeah.
So
It's a part two of a question. I don't think we're going to be able to. Well, let's take a crack at it, right?
Yeah.
2 kids, one of them in the U.S. born here, recently came here to pursue education, who'll be 21 years next month. What are the best paths to get them green card without separation of the family?
EB5, if you're born in India, because you can file an adjustment of status
Immediately,
and lock that kid under the Child Status Protection Act if he's will be 21 in next month. So you got to file that EB5 before next month.
Yeah.
That's really, really tough to do.
Yeah.
And so that's a tough question. I'm going to take one more here. Hey, I took EB2 green card interview last week. Unfortunately, my company was purchased by another company and I filed supplement J. Did not know about portability law and she passed my case to supervisor.
So, so what looks like there's a follow-up.
My status as an interview was completed. It must be reviewed. How long will it take? Well, the devil is in the details, whether or not you really need to have a consultation with a competent attorney that can help you figure out whether more has to be done, like an I-140 amendment. It depends on the type of purchase. This is a complicated question, and you really need an attorney to review it.
Yeah, I mean, my inclination is, I'm going to presume if you've gotten into an interview at this point, you're probably beyond the portability rules, so handing in a supplement J. Doesn't surprise me that the officer doesn't know the portability rules. We've definitely encountered officers that don't know the portability rules for I-485.
Mm-hmm.
And how long will it take?
When the supervisor is educated and then look at it, if your visa is available, visa availability is no problem.
That's the thing that I think about too. If visa availability is the more likely the issue. If your party date's current, I mean, sooner rather than later. I wouldn't expect 6 months or anything like that. I would just hope with a couple months.
Mm-hmm.
So,
Mm-hmm.
yeah.
All right. Well, thank you guys for listening us today. Next week, 6 o'clock, we'll send you the topic and send us any suggestions. Happy to oblige and include your suggestions in our next presentations. Have a great evening.